Good afternoon, everyone. I am Deputy Attorney General Lauren McGuire, and you are here today for the Freedom of Information Act annual training. I am just going to do a few introductory slides, and then we'll get into sort of the meat of the presentation. A couple disclaimers first. The legislature has specifically provided that this presentation is not to be construed as legal advice. So any specific questions related to your entity or legal questions in particular, you can save those for your counsel. The information that follows today summarizes the law. We can't cover every situation, and we cannot address fact-specific questions. So as I said, if you do have a fact-specific question, we would encourage you to contact your legal counsel. If you have a general question related to FOIA, we would encourage you to review the FOIA manual. That is updated every 2 years and will be updated this week. I know it's been complete as of this morning. It hadn't been updated on the website, but it should be very shortly. This slide, I'm not going to read to you, but gives the legislative declaration for FOIA. The goal of FOIA is to encourage openness. We would encourage public bodies to lean in favor of transparency, even if an exemption may apply to a request that you receive. We encourage you to consider whether a record can be released in appropriate circumstances when you're also considering those exemptions. Moving on to the purposes of FOIA. FOIA is designed to promote governmental transparency and accountability, to allow citizens to be informed about what is happening, and to make it possible for citizens of Delaware to observe and monitor the performance of public officials. The FOIA manual, which I mentioned earlier, is created by the Department of Justice to assist FOIA coordinators. It's found on the Department of Justice's Open Government webpage. It's intended, as I had mentioned before, to be an easy reference for FOIA, addresses some background information and common situations. And that manual is updated every 2 years. This is the annual FOIA training. It's intended to provide guidance for FOIA coordinators and the public, as well as others involved in responding to FOIA requests. Today's presentation will discuss the FOIA statute, cases, and Attorney General opinions that interpret the statute. I know that I need to go through this slide, but it talks about what the presentation will cover. Up next is going to be FOIA coordinators' duties and responsibilities, and that, I'm going to turn it over to Deputy Attorney General Dory Cole.
Thank you, Laura. Good afternoon, everyone. I'm Dory Cole, as she said. And in this section, we're going to be discussing the duties and responsibilities of the FOIA coordinator. We're going to mostly focus on sections 10,003 and 10,005 of the statute. All public bodies must appoint a FOIA coordinator who serves as a point of contact for citizens requesting public records, and that person is responsible for tracking and processing those requests. The FOIA coordinator must be identified on the public body's website. The coordinator's name and contact information must be sent to the Department of Justice. And if there's any change to that information, the public body is to update the website and provide the updated name and contact information to the DOJ within 20 business days. The email account for the DOJ FOIA office is listed on this slide. It's open government at delaware.gov. Next slide. So what are the main duties of the FOIA coordinator? The primary duty is processing all FOIA requests from start to finish. That begins with tracking the requests as they come in, assisting requesters who may need help figuring out what records they're seeking, and coordinating with internal staff to locate records and provide a response to the request. The overall goal is to foster cooperation between the public body and the requester. And also the coordinator must maintain the log for tracking all the FOIA requests the public body receives. So what information needs to be tracked on the FOIA log? The statute is very specific about the items that need to be included. They include the requesting party's contact information, the date the FOIA request was received, the response deadline, the date of the public body's response, including the reasons for any extension, the names, contact information, and dates of correspondence of those contacted in connection with a FOIA request, the dates of review of any documents that are responsive, names of individuals who conducted that review, whether the documents were actually produced, the amount of the fees, and the date of the final disposition of the FOIA request. So all those items must be addressed. And if you need a sample of the policy manual that Lauren mentioned earlier, that's available on the website. Appendix B has a sample log that you can refer to. One final item that I want to mention is that the log itself may be requested by a citizen through FOIA, so it's important to keep the log updated. There's a recent Attorney General opinion 21 IB 27 that found a violation when the public body failed to track all the items required by the statute. The opinion also determined the FOIA coordinator should update the log regularly. The opinion discouraged the practice of retrospectively creating or substantially revising FOIA logs to comply with FOIA requests for FOIA logs. So Section 10,003 covers several other topics, including the form of the request, how to respond to a FOIA request in general, how to respond to two specific types of FOIA requests, the requests for emails and non-custodial records. The statute also identifies what records are exempt from public disclosure, discusses how to provide access to the records, and talks about fees that can be assessed for searching, copying, and producing records. Next, we want to talk about what happens when your response to a FOIA request is challenged. Section 10,005 discusses the recourse citizens have when they believe a public body has violated FOIA. One option is to file a petition with the Attorney General to make a complaint about the public body's conduct. Yes, thank you. For example, a citizen may file a petition alleging the public body improperly denied their FOIA request. The Attorney General would review the positions of the petitioner and the public body and issue a written determination regarding whether a FOIA violation occurred. And I'll also mention that a citizen has the option to file a lawsuit. I won't go into a lot of detail, but Section 10,005 discusses how a citizen may do that. On this slide, there's also a link to our rules of procedure for FOIA petitions and determinations. These procedures describe the requirements and the process for FOIA petitions in more detail. So, for example, they set forth the time limit on filing a petition. So for state entities that deny a records request, the petitioner has 60 days from the day of denial to file a petition with our office. For all other requests, which include claims of open meetings violations, including state and non-state entities, and records request violations involving non-state entities, petitioners have 6 months to file a FOIA petition. And this last bullet point on the slide is the link to the webpage where all the Attorney General opinions are posted. This webpage is a great resource if you or your counsel would like to research a FOIA issue. The opinions are arranged chronologically, and they can also be searched by keyword. So that is the basics of the FOIA petition process. The final topic we're going to cover is when a public body receives a petition, how does it prove that it's complied with FOIA? This is one of the big changes in FOIA law in the past few years. There's been a series of cases making their way to the Delaware Superior Court and the Supreme Court involving Judicial Watch and the University of Delaware. Those cases have been finally resolved in this past year, and one of the main principles resulting from these cases is that most of the time a public body is going to need to provide an affidavit with sworn statements detailing how it complied with FOIA law. So on this slide, we have a couple of the major takeaways from the Judicial Watch cases. These cases involve several claims about a records dispute, including the claim the university failed to properly search its records and failed to meet its burden of proof. The university is exempt from parts of FOIA, but the case offers some general guidance that all Delaware public bodies can apply. And the first thing is that the Judicial Watch cases clarify is when a public body is required to search for records. When it's not clear on the face of the records that they're not subject to FOIA, you must search for those records. An example of clear on its face would be a citizen asks for someone's public library records, and all records of a public library identifying the patron and what they've checked out are exempt from FOIA. That's under exemption 10,002-012. So there's no need to search for that type of document. It's clear on its face that those records are not public. So when a citizen believes that a public body violated FOIA, the public body has the burden of proof. In other words, it's the public body's burden to show that it complied with FOIA. So that means if the response to the request is challenged and the records are not clearly exempt on their face, you need to produce a detailed sworn statement of the steps you took to perform the search and the outcome of that search. So for example, including who provided the information, when the inquiries were made, and what documents were reviewed. And when it's not clear, you also want to be able to explain why certain areas were selected to be searched. A general statement in the affidavit, such as these are not public records, is not sufficient. An unsworn factual statement, even if they're made by a legal counsel, also won't be sufficient. And just one final note is that even though the Judicial Watch cases involve a records dispute, the court's discussion implies that all factual representations, including those about open meeting violations, would need to be sworn in an affidavit. So to reiterate the earlier slide, in most cases, the public body will need to submit an affidavit in defending a FOIA action. And in this last slide, if you'd like to take a look at these cases and provide them to your legal counsel, here is a list of the citations. Reviewing the cases will provide more insight into how the issue evolved and help you be prepared to face any challenges under FOIA you have. That wraps up this section. The next section will be presented is responding to requests for public records.
Thank you, Dory, for that presentation on FOIA coordinator's duties and responsibilities. Good afternoon. My name is Ed Kosmuski. I'm a Deputy Attorney General, and my presentation will be responding to a request for public records. So, public records. In order to respond to requests for public records, we first must ask ourselves the question, what's a public record? So, public record is defined in section 10,002 of FOIA, and it's a mouthful. It's information of any kind owned, made, used, retained, received, produced, composed, drafted, or otherwise compiled or collected by any public body relating in any way to public business or in any way of public interest, or in any way related to public purposes, regardless of the physical form or characteristics by which such information is stored, recorded, or reproduced. Like I said, it's a mouthful. Bottom line is, public records include all information contained in physical documents, typically paper, as well as information stored electronically, such as Word, PDF, PowerPoint, Excel, etc. It also includes databases relating to public business. As a practical matter, the FOIA's concept of public record covers, subject to various exceptions, almost every conceivable type of physical or electronic record that may be created, maintained, or possessed by a public body. So if the definition of public record is so incredibly broad, is there anything, you're probably asking yourself, is there anything that's excluded from the definition? And I'm glad you thought about it and asked. There are. There are statutory exceptions to public records, which are found in section 10,002(0) through 19. I'm not going to list them all, but the records listed under these subsections have been specifically exempted from the definition of public records. Some examples I'll give you are public personnel files, employee personnel files, medical files, student files, trade secrets, confidential information, civil or criminal investigatory files, records involving labor negotiations or collective bargaining, and certain records pertaining to litigation. In addition to the specifically listed exclusions, certain records may be specifically exempted by statute. And in this category would include tax records, which is protected from disclosure by Delaware Code, specifically 30 Del Code 368. Records may also be exempted by common law doctrine, such as the attorney-client privilege. So although the aforementioned is not a complete list of all the records excluded from the definition of public records under FOIA, the Delaware Code or common law, there are many applicable exceptions. You should familiarize yourself with the exceptions listed under 10,002(0) through 19. And if you have any questions regarding a specific request or exemptions, you should consult the attorney for your agency or organization. FOIA policy. So FOIA requires that all public bodies implement and promulgate policy to address FOIA requests. So the FOIA coordinator should familiarize themselves with their public body's policy. And it should go without saying, the public body's policy cannot violate FOIA. Although public bodies must, 1, designate a FOIA coordinator, 2, provide a mailing address for receiving FOIA requests through the U.S. mail, and 3, develop a web portal for receiving FOIA requests through the internet. FOIA also notes that FOIA request form may be obtained from the website of any state agency, school district, or other public body. So you should make sure as a FOIA coordinator that a form is available on your public body's website. That being said, the FOIA request may not be denied solely because it doesn't comport to the form that's provided and not used to make the request. Additionally, a FOIA policy may include provisions for the waiver of some or all administrative fees. However, the waiver must apply equally to a particular class. An example would be nonprofit organizations. All right, so the next up is the obligation to search file. So what's the public body's obligation to search its files to identify public records in response to a FOIA request? Basically, it comes down to answering this question, and Dory picked up on it earlier today. Is it clear from the face of the request that the demanded records are not subject to FOIA? Unless it's clear on the face of the request that the demanded records are not subject to FOIA, the public body must conduct a search for responsive records. Additionally, the public body may also need to work with its IT professionals to locate email records. And I'll get to email records in a little bit. So what are some of the important deadlines when it comes to responding to a FOIA request? FOIA requires that a response to a FOIA request be made as soon as possible, but not later than 15 days after receipt of the request. The 15 business day excludes weekends as well as holidays and other days the state offices are closed. So next question is, when does the 15-day period begin? It begins when the request is received by the public body, pretty much when the designated FOIA coordinator receives the request. And this is another reason it's important to track those requests and put the date you received it, so you have the date that it has to be responded to. So what happens if you miss the deadline? If a public body misses a deadline, it's best to provide a response as soon as possible, even if the petition has been filed with the AG's office. So don't just ignore it. So what constitutes a response? The public body must respond with a minimum with one of the following: that the public body is granting access to the records requested and provide the records, indicate that access to the records is being denied in whole or in part, and include the basis for that denial. And then 3 would be indicate that additional time is needed. If additional time is needed, the response must include a good faith estimate of how much time will be required to fulfill the request. So let's go forward with additional time. So what if additional time is needed to respond to the request? If additional time is needed to compile the records, a response must be sent that indicates the additional time is needed and must indicate one of the following statutory bases for the extension. 1, the records are voluminous. 2, the request requires legal advice in connection with the request. Or 3, the records are in storage or archive. Additionally, as previously noted, the response must include a good faith estimate of how much additional time is needed to fulfill the request. A response of ASAP or soon will not likely withstand scrutiny. So as I mentioned earlier, get back to request-seeking emails. So FOIA requires that each public body attempt to fulfill requests from its own records using reasonable efforts of its own staff. So in most circumstances, third-party providers should not be a public body's first point of contact for obtaining email records. Doing so will likely be deemed unreasonable. Only after an exhaustive internal search should the agency seek assistance from a third-party technology provider. However, before requesting DTI or a third-party provider, the public body is required to provide an itemized cost estimate to the requesting party regarding the cost it will incur to obtain those charges. Upon receipt of that estimate, the requesting party can decide whether to proceed, cancel, or modify its request. So next up are suggested steps. So what steps should the FOIA coordinator take when it receives a request for emails? In most instances, FOIA coordinator should take the following steps. 1, identify the employee or employees most likely to have access to the email records identified in the FOIA request. 2, request those employees to search their emails for records that are responsive to the request. If an employee cannot be identified or cannot conduct the search, first work with internal IT personnel to search for the email records. If the public body cannot obtain the email records requested from its own records after using reasonable efforts, it should then contact the public body's third-party service provider to assist with the search. But as mentioned earlier, prior to moving forward that assistance, if there will be fees associated with retrieving the email records, the public body must provide the requester with an itemized written cost estimate listing all charges expected to be incurred in retrieving the records prior to retrieving those records. As noted earlier, upon receipt of the estimate, the requesting party may decide whether to proceed with, cancel, or modify the request. All right, request for non-custodial records. So if a FOIA request seeks records that are not controlled by the public body or not in its possession and cannot otherwise be filled by the public body without reasonable effort from the records in its possession, then the public body shall request the custodian holding the records to provide such records to the public body. So similar to an email request, if there will be fees incurred in obtaining non-custodial records, the public body is required to obtain an estimate and then provide an itemized written cost estimate to the requesting party, listing all the charges expected to be incurred in retrieving such records prior to having those records retrieved. Once again, once the requesting party receives the estimate, they can decide to proceed, cancel, or modify the request. All right, next up is a denial. So if a FOIA request is denied in whole or in part, the public body must include a reason for the denial in its response. However, the public body is not required to provide an index or any other compilation listing each record or part of a record that was denied. As an example, a public body does not have to produce a privilege log to support a denial of documents under either the attorney-client privilege or the attorney work product privilege. All right, so this pretty much concludes my presentation on responding to records for public records. But before I turn over the presentation to Joe Hanlon, I was asked to bring to your attention that effective September 21st, 2023, a new FOIA section was enacted, Section 10,008, which is titled Live Streaming Board of Trustee Meetings of Public Institutions of Higher Learning. While this new section will not be relevant to the majority of FOIA coordinators, the FOIA coordinators of the University of Delaware, Delaware State University, and Delaware Technical and Community College are encouraged to review the new section. And with that, I'll turn over the presentation to Joe Hanlon.
Thank you, Ed. Good afternoon, everybody. Good afternoon to everyone online. Again, my name is Joe Hanlon. I'm a Deputy Attorney General in the Civil Division, and I am here to talk about fees and what we charge. So fees are permitted by the statute, as probably everyone knows. Expressly permits the public body to charge for fees. So some general principles. There are limits to what can be charged, and the fees should be minimized. I think as Lauren mentioned at the outset of today's training, we should minimize fees to the greatest extent possible, consistent with openness and responsiveness of government bodies under FOIA. Interestingly, though, bodies may adopt an alternative fee schedule either in the Delaware code or in municipal and county codes. I'm not actually aware of any public body doing that, but that is authorized by FOIA. So FOIA's minimums that we're about to go through are set forth in the statute, but there could be, they could be legislated out of. So administrative fees, this is probably the most, somewhat vague section of the fee section in FOIA. And again, I should have mentioned subsection M of 10,003 is where all the entire place in FOIA dealing with fees. The statute suggests that administrative fees are actually required, but it allows agencies to adopt policies. And as you heard already, agencies should have policies on FOIA that waive fees. Administrative fees are permitted, but not for the first hour. So if a search is only going to take an hour or under an hour, do not try to charge. A public body must also attempt to minimize the administrative fees and charge only those fees, again, that are reasonably required to process the FOIA request. So photocopy fees, it's all there, it's all in the statute. I'm not going to repeat them, but just noting that the first 20 pages are free. So you can't charge for just a couple pages. You can't charge for the first hour of administrative work. So that should cover a lot of FOIA requests. And then after 20 pages, the statute authorizes 10 cents per sheet. So if you haven't opted out of the actual state FOIA statute, that's what's allowed to be charged. And you have very specific charges for oversized copies, double-sided, and color copies. All right, so what's permitted? Staff time associated with processing requests. And what does that include? That includes identifying the records, because sometimes you get FOIA requests that ask for all documents that relate to a certain topic, not specific documents. We get that a lot of times. So time identifying what records are responsive to the request. Monitoring file reviews, doing the file reviews, and generating computer records, whether electronic or on paper. So that's the time that's permitted for administrative fees. The fees must be billed per quarter hour and at the hourly grade of the lowest paid employee capable of performing the service. So that means, that could be someone higher up in the agency or in government, but you have to be able to justify that that person was the person needed to do that search. So no legal review. What's that? Fees may not be charged for the legal review of the response. The Attorney General's office has interpreted it as follows. This is first and foremost, this gets confused a lot. It is not just limited to lawyers. If anyone reviews a request and does a file review or a document review in an agency to determine whether or not an exception applies, that has been considered a legal review. So it could be an admin, someone fiscal doing that. If they're looking to see if a particular exception applies, that is a legal review. Subject matter, the slide says is an exception. It's not really an exception. It's not a legal review if you're looking for documents that are basically responsive to the request. So that would be a subject matter review. And there is at least one FOIA opinion on that topic and probably more. Fee waivers, I think that was already mentioned, must comply with the policy that's in place and must be applied consistently. So there has to be some consistency how any kind of waiver is applied. Other charges, I don't know how many of us are dealing with microfilm and microfiche. Maybe this will get edited out of the FOIA statute at some point, but there are specific charges there for that. I guess more importantly, FOIA touches upon electronic records. You can actually charge for the material costs, the thumb drive, the disc. They're increasingly pretty minimal charges, so I would be cautious about charging for that stuff. Third-party custodian fees, and Ed already touched upon that. That is a much bigger potential cost and something that should be analyzed very thoroughly before exploring that. All right, so estimates, I think this was, Ed touched on this as well, but it bears repeating. Itemized written cost estimates for administrative fees. They must be provided to the requesting party, and all charges expected to be incurred in retrieving the records. And again, the requester at that point can make a decision about whether to go forward. Importantly, estimates must be done in good faith. You see the term good faith a lot in the law, and in this context, it means you don't want to discourage, you don't want to just overestimate to discourage the FOIA request. The Attorney General's office and potential other assessors will see through that. But at the same time, you don't want to get in the business of creating a collection action. So you have to be very careful how you estimate the cost, and that's sometimes easier said than done. Once you do estimate and you provide that estimate to the requester, you can request advance payment prior to producing the records. And I think this should go without saying to everyone, if the estimate exceeds the actual cost, you have to refund. So just a quick summary, some takeaways from the fee section. Again, subsection M of 10,003, not for the first 20 pages and actually, it should be under 1 hour. 1 hour under, not my bad. Ensure that the fee collection practice complies with the statute, obviously, in any internal FOIA policy, and you should have an internal FOIA policy. And then just a general kind of standard, ensure that that reasonableness is employed. You'll see that throughout the Attorney General's opinion, reviewing fees, and the overriding factor is kind of all the circumstances are at play and whether the request is reasonable. And again, estimates in advance can request prepayment. If you review some recent decisions on fees, it'll be really instructive as to what our office has found to be reasonable, what has been found not to be reasonable. These are two recent opinions, and you have the sites there. Two-step process. That involves the state agencies. There's a lot where we are reasonable actually going to DTI first, because DTI can retrieve a vast array of emails touching on a particular topic, and oftentimes we do that, and they will assess a fee for that. But that's one step. The other step is the agency then having to maybe look at other documents that are responsive to the request. So if the FOIA requester doesn't want to pay the $50 or $80 that DTI is assessing, we can get that estimate out first. If that estimate is provided to the requester first, there should be very specific language in there about this potentially not being the total estimate. So that came up in 23 IB03 just earlier this year. And in the context of that case, which you would have to read for yourself, it was found to be okay. Can charge for redactions, the time for redactions, but that's tricky because if you're redacting for exceptions, then that could be considered a legal review. So you have to be careful there. If management is used, and we see that sometimes, you just have to be very explicit as to why you had to use an executive to perform the FOIA search or the help and respond to the request. And that's got to be in the affidavit. And then 22 IB45 from last year, just by way of an example, 5 hours, total of $200 was an estimate for some tag sheets. I'm not sure exactly what those are, but DelDOT had those, and they had various project names and other information on them. They had to be compiled from a bunch of different areas within DelDOT. They were not in a particular location, and the requester took a lot of exception to the fact that they weren't maintained in a certain way. And this opinion explained that FOIA does not require government agencies or municipalities to maintain files in a particular way. And under the circumstances of that case, found that that was reasonable. And again, an affidavit explaining who did what and why was helpful. And at this point, I will turn it over to Victoria Groff to talk about open meetings. Thank you.
Thank you, Joe. Open meetings is a crucial part of many public bodies, and under 29 Del C 10,004 B through D H, all of those meetings of a public body must be open to the public unless they're specifically exempted in the FOIA statute. And The meeting has been found to be, or defined as a formal or informal gathering of a quorum of the members of any public body for the purpose of discussing or taking action on public business. Before you have a public meeting, you need to have a notice set out. That is under section 10,004 E and F. And public notice is required for all regular meetings. And if there is any intent to hold an executive session at that regular meeting, it needs to be put on the agenda at least 7 days in advance of the meeting. If the agenda is not available at the time of the initial posting, for some reason, it must be added to the notice at least 6 hours in advance of the meeting, and there needs to be a reason given for the delay in the posting. There are exceptions for emergency meetings necessary for immediate preservation of public peace, health, or safety, and the General Assembly. So that will probably be a very specific exception, but there is an exemption for that. And on the notice, you need to have the time, date, and place of the meeting, and whether it will be conducted under section 10,006A. And the preliminary agenda needs to include an executive session if there is an intent to have an executive session held. And executive sessions will be discussed later in the presentation, and how and when you can use those appropriately. The agenda cannot include a catch-all category. That's not permissible. That's from the Chemical Industries Council of Delaware case. And after you have the meeting, you're required to have minutes. And the minutes include executive session in terms of listing if there was an executive session and the reason for it. But in the minutes, generally, you need to record all of the members present, each vote taken, and each action agreed upon. If there are members that come in late or are leaving early, you would want to note those in the minute meetings as well. And unless the vote is unanimous, the minutes must state how each member voted and any members who abstain or any members who recuse themselves from that vote. And another note on executive session, those minutes may be withheld from public disclosure. So the actual minutes of that executive session, but only so long as the public disclosure would defeat the purpose for the lawful purpose would defeat the lawful purpose for the executive session, but no longer. And that's under 10,004 F. Gonna get back to Joe.
Hi, I'm still Joe Hamlin. Good afternoon again. Public comment session. Anyone here familiar with Senate Bill 293 from last year? So Senate Bill from 293 last year proposed to make it mandatory to have public comment sessions at every public meeting, except for the General Assembly. This was something that probably most of you did anyway, or your boards or your agencies did anyway. I know a lot of state agencies have done them for years, but now it's mandatory in FOIA to have these. So Senate Bill 293 was initially proposed, and then it was substituted for House Substitute number 1. So basically it requires, again, meetings open to the public, must provide for an opportunity for public comment, except the General Assembly. The time must provide meaningful opportunity for the public to engage with the public body. So that's the standard. The public body may impose reasonable time, place, and manner restraints on the length of the public comment period, which is the entire time for public comment, and then on each particular person who may or may not come to comment. 293 originally allowed for restrictions on content, but House Substitute number 1 removed that. So SB 293 originally didn't have meaningful opportunity language. And you can go to the next slide. So some interesting questions came up from this. I sometimes think sometimes FOIA could be a little dry. And when I was asked to do the public comment period section of this presentation, I similarly thought it was probably going to be a little dry. But then I've dealt with a lot of litigation in my experience at the Department of Justice and First Amendment issues. So interestingly enough, the public comment periods a lot of First Amendment issues are implicated. So one being, I think these things fly in, can you limit the content? So you have an agenda, the public body meets for a particular reason, and then someone comes to comment on something completely off the wall. Maybe it has nothing to do with even that public body. Maybe it has something to do with an agency that's, you know, a separate agency. Maybe someone wants to start commenting about federal politicians. So can you ask that person to stop talking? This is what you all need to think of. These are interesting issues that are raised. Now, the only guidance I would give, subject to our qualifications at the beginning, is that the original Senate Bill 293 had the following language in it. Don't get old. It actually said that could limit the public comment if it's irrelevant, immaterial, insubstantial, cumulative, or privileged. And that did not make its way into the House substitute number 1. So the House substitute number 1 just says meaningful opportunity for the public to be heard. So consult with your counsel, but there is something to be said about legislative history and how bills are developed. So perhaps that is a reason not to limit the content of what someone's saying. There also is a bill memorandum out there online written by a commissioner who strongly advocates against limiting the content. And once government does limit content-specific regulation usually bears a lot of scrutiny by the court. So be very careful. Might be wise to not limit the content. Relevance, same issue. First Amendment, we talked about that. The First Amendment, it certainly is implicated by public meetings and public comment sessions. There's a lot of litigation over this. And this was an interesting one. So there is a decision from the Attorney General's office. It's pretty old. It's from 2005, certainly before 293, that talked about this. And there was a school board meeting, and this is 05 IB 01 that you can find, or your council can find. But this was a situation where there was a public comment session at a school board meeting, and someone got up to talk about matters that, if the public body, the school board, was talking about it, would be a personnel issue and subject to an executive session. So they would be rightly able to go in an executive session, and one of the school board members stopped that person from talking because they were going to bring up personnel matters. It was just critical of teachers, particular teachers, and it was awkward. And that was held to be a violation. So once you are specific as to the content, the public body really risks running afoul of the First Amendment. That same decision also upheld a 2-minute limitation on speakers. That may not always be reasonable given different contexts and situations, but the limit on how much time, I get that a lot from public bodies about, well, how much time do we have to let this person speak? Sometimes you get someone that might have an axe to grind or a particular agenda, and the inclinations to limit that person to shorter time period. But you have to be consistent. Content-based limitations are probably a bad idea under most circumstances. So those are some of the issues that we were all going to have to deal with. Again, the public comment period is not brand new, but is now mandated by law, and the parameters are set forth in 290 House Substitute 1 for Senate Bill 293. Okay. Now I'm going to turn it to Eric Zubrow to talk about executive session.
Afternoon, everyone. I'm Eric Zubrow. I'm also a Deputy Attorney General. So I'm up here to talk about executive sessions with you folks. For the layman or the folks new to FOIA world, executive sessions are the opportunities for a FOIA applicable entity to meet outside of the public in organized fashion during a meeting. So this slide just concerns some logistics related to that. You're in an open meeting, as I stated. A motion is held, which states a broad general reason, which we'll talk about some of the reasons for executive sessions momentarily. You then move into executive session. The executive session is limited strictly to the topic for which you're going into the session in the first place. You cannot waiver or go into other topics that would justify coming out of the executive session. And the big thing, which is underlined on there, highlighted, there can be no voting in executive sessions. So if you go into session to discuss a topic, you need to come out of session before you hold any type of vote related to that specific topic. Now in 29 Del Code 1004 B, there are a list of specific justifications to go into executive sessions, much like 1002 with the exceptions to public records. It's very similar. I'll read through these real quick. These are kind of the obvious, easy to understand ones. Justifications include individual citizens' qualifications to hold a job or pursue training, preliminary discussions on site acquisitions for any publicly funded capital improvement or sales/lease of real property, law enforcement agencies' efforts to collect information leading to a criminal apprehension, discussions of identifiable lawful or charitable contributors when an anonymity has been requested, student disciplinary cases unless open meeting is requested, employee disciplinary cases or dismissal cases unless the individual requests that it be open. And finally, personnel matters when the names, competency, and abilities of individual employees or students will be discussed unless an open meeting again is requested. We highlighted two specific subsections, B4 and B6, because they're a little more, they're worthy of a little more discussion here. B4 concerns strategy sessions, including seeking legal advice, but only if open discussion would have an adverse effect on the public body's collective bargaining or litigation position. And they're listed below are proper discussions, which include collective bargaining, pending litigation, potential litigation. If there is contemplation of going into a session for one of these reasons, I'd urge you to consult legal counsel because there's tests that have been enumerated through FOIA opinions from the AG's office stating, kind of what facts need to be applied to the test in order to justify going in, specifically for potential litigation, which is a little bigger than pending litigation when you actually have a case on the books versus one that may or may not happen. The second, B6, and this is where 10,002 comes in, discussion of non-public documents. So if the goal of if you need to talk about a public record, in the sense of like a document that would not be considered a public record under 10,002, you have the ability to go into executive session to talk about that document. Now, again, going back to what I said before, you need to restrict that conversation to discussion of the document itself. You go outside the document or talk about anything else, you've lost the ability to legally go into executive session or stay in executive session. And finally, just some information about attendance. Executive sessions are for council members only. Now, there are some exceptions to that. If there are support staff that are needed, those people, as long as the public entity has a justification for those folks, if it is challenged down the road, if you need someone there to work the PowerPoint, that could be a justification for having a person in executive session, for example. Similarly, if you have a speaker coming in to speak to the council and that topic is outside of what should be in a public session, then that's another reason to have somebody outside the council there. And then the last bullet just notes if somebody's recusing themselves for whatever reason, they should not be a member or they should not be participating in the executive session. Thank you.
Good afternoon, everyone. I'm Kayla Spielter, again, Deputy Attorney General in the Civil Division. And we're going to be talking a little bit about virtual meetings. This is probably one of the more recent changes to the FOIA statute, one that I think was extremely welcome to the community. And if you have not heard this information before, then hopefully this will give you a little bit of an overview. So first, we're going to look at the history of virtual meetings. Virtual meetings in any form were first approved in 2009 by Senate Bill 104, which allowed for video conferencing. After that, we didn't see an update to the virtual meeting statute until the COVID pandemic kind of caused the state to, of course, reevaluate a whole lot about how we do business. And in 2000, there was a temporary Senate bill that expired in June of 2021, which allowed virtual meetings to replace video conferencing. Then finally, again, in June 2021, the former video conferencing provision was formally replaced with the permanent changes to FOIA as we have them today, which allow virtual meetings. I just want to point out that if you read the text of the bill as proposed, it talks about several reasons why virtual meetings are so important. Of course, the pandemic made it that much more obvious that they were necessary, but virtual meetings do allow greater public participation, especially from members of the public with disabilities. But the legislature is also very cognizant of the fact that not everybody has access to the virtual platforms, and so therefore attempted to strike a balance between the access and ease of virtual meetings while also allowing the public to attend in person. So, how does a virtual meeting occur? It is mandatory for every public body to allow a board member with a disability to attend a meeting through electronic means rather than in person as a reasonable accommodation. That falls in line with the ADA and was included in our statute as one means of allowing that access. However, it's also discretionary that a chair or presiding officer may call a virtual meeting. And if a virtual meeting is called, there are a specific set of rules about how that meeting must be conducted. First of all, the meeting notice, as discussed previously, has to include instructions on how the public can monitor or participate in the meeting. That could be the platform it's being presented on, links, other access. The meeting also must have an anchor location. So that is a physical location within the geographic jurisdiction of the public body, open to the public, at which one or more members of the public body may attend a virtual meeting. In practice, that generally looks a whole lot like a conference room where something not too dissimilar from this is set up, where the public can monitor either visually or through speakers the public meeting. Member and witness identities must be verified and their actions authenticated to the satisfaction of the chair. And those items are in quotes because those come directly from the statute. Members and witnesses must be able to do one of these things: hear the comments of each member or witness, so essentially that's telephonic or via a speaker system, or hear the comments of and view each member or witness. A few more rules. A document that is accepted by the presiding officer or chair must be provided to every member during the meeting and made available to the public under section 10,003. And the public must be able to monitor the meeting through electronic means, except for executive session, as we just discussed. A recent case, 23 IB08, specifically ruled that audio access alone is sufficient to be considered monitoring by the public. So again, you do not necessarily have to have video capability set up. Audio monitoring is sufficient. If a public comment period is held as part of the meeting, the public must be able to provide public comments, including virtually. So that means that whether you're talking about a video or strictly an audio setup, there must be means for the public to participate. And minutes of the virtual meeting are still required, just as with in-person meetings. While not strictly relevant today, because we are no longer under a state of emergency, the COVID-19 emergency ended on May 11th of this year, I still thought it would be nice to very quickly discuss how these rules differ in times of state of emergency, because it's always possible we'll find ourselves in a situation like that again. And the state agreed the exceptions to virtual meetings for a state of emergency were codified as part of the rules. So again, all of this only applies during a state of emergency. Any public body can hold a virtual meeting during a state of emergency, and all board members are permitted to participate by electronic means. During a state of emergency, no anchor location is required, but otherwise all the same public notice requirements apply. Except for the requirement that the posting must be at the principal office or where the meetings are regularly held. Again, this takes into consideration the idea that the public may not be out and about, so we're not going to require an anchor location, and it's not going to be required to post the meeting notice in that location either. If the law requires a public body to keep a verbatim transcript, then the public body must still keep that verbatim transcript even during a state of emergency. And then this last point here is only for elected public bodies, so it may or may not apply to you specifically, but for elected public bodies, a document used during the meeting by a member or witness that is accepted by the chair must immediately be transmitted to each member or witness participating, and the public must be able to view a recording of the meeting within a reasonable time after the meeting concludes. I am not aware of a specific case that decides what a reasonable amount of time is. It will probably depend on the fact-specific scenario. Again, if you find yourself in that situation, please consult your own legal counsel who will be able to guide you. Just a few final words. All actions taken during a virtual meeting have the same legal effect as if it were an in-person meeting. Virtual participants, those who are only appearing via audio or video capabilities, do count towards a quorum, and they are allowed to vote just as they would if they were in person. Technological problems that limit public access will not invalidate the meeting or actions taken during the meeting, but of course, it's always in our best policy to try and avoid them and have someone on hand to be able to deal with them if they do arise. And that ends our presentation on FOIA. Following that, we're going to have an opportunity for questions and answers, and then we're going to have a bit of a panel discussion. So for those of you in the room, are there any questions about the presentation? Yeah.
Thank you. Can you hear me?
Of course.
Yes, I have two questions. One's about open meeting. That question is, do doors have to be open to an open meeting, or can they be closed during open?
If anyone is more familiar with this, I believe that the doors may be open but should be remained accessible. So much like the door to this room, where the door is physically closed but is unlocked and people may enter as freely.
The reason why I'm asking is because at school board meetings, I noticed I was a member of a school district for a long time. I thought there was something called an Open Meeting Act. And during the Open Meeting Act, I thought the doors had to be open, because if it didn't, they would give people the impression that it was a very closed session. So there's no violation then if the doors are closed during the meeting, even though it's open meeting.
I am not familiar with anything in the statute that indicates whether doors or other entryways must remain open. Any of my other colleagues?
I think a good point is a lot of times public bodies will have signs up that, so as long as there's like a sign on the door, you know, for that meeting, and the door is unlocked or otherwise accessible to be opened. You know, obviously if the door is locked, I think that would not pass the test, but if it's just closed to keep the sound from the hallway coming in or interrupting the meeting.
So there's no law that says it has to be open.
Not that I'm
not
aware of.
aware of
I'm not familiar
I
with
know.
the school board act that you referenced, so there might be.
Besides actually just asking, because I noticed that like the board meetings, they're always open, the doors are always open, and there's something about the Open Meetings Act.
Now, we're very familiar with state law, so you all have to make sure there might be a county or municipal law that might say something very specific to that,
Great point, Joe.
but I would be surprised.
I think it's just the appearance, to avoid the appearance of.
Right. Good practice.
There's no law.
That's a good point. Not that we're aware of, like Joe said, we're mostly familiar with state. There are specific local and perhaps even school district or school charter specific.
And I think I know the answer to the second question. During the executive session, during COVID, we had a lot of hybrid meetings. My job, and our board members, some board members would be present, but some would be, of course, at home. So is there a quorum? Can they vote? That physically then?
As I just said, as long as the virtual meeting is being held within the procedures that we just talked about, you know, having the proper notice, having an anchor location, then yes, any executive session held in that virtual meeting is still considered a fully valid legal open meeting, or therefore executive session of that meeting. So
Thank you.
as long as you just gotta make sure you're checking all the boxes in the statute. And pretty much what was taken here was taken exactly from the statute. So you can always go back to that as your reference.
Okay.
Of course.
So if we want to move to the panel.
Did you have any questions on me? Check.
We did have questions. I'm going to actually pose them to panel.
Okay.
So, although there was one question that I can answer very quickly, will you get copies of this presentation if you're not here physically? If you are here physically, there are copies of the presentation on the back of the room. If you're here with us virtually, there will be copies that are posted on the website very shortly if they're not already posted. Thank you. All right, and have our camera set up and our mic should be set up. And I am monitoring the chat via email through the help of another one of our DAGs. So if there are questions from the audience or the virtual audience, feel free to put them in the chat and I will try to get to them. So we have with us 3 FOIA coordinators. If each of you could just introduce yourself and let the audience know what agency you've worked for, about how long you've done it, if you've had any other FOIA experience, about what portion of your time is devoted to FOIA, and if you have any significant lessons or pearls of wisdom that you want to pass along from your experience of becoming or serving as a FOIA coordinator, we would love to hear it. So, any takers?
Yeah, that's fine. How you doing? My name is Marshawn Howard. I'm the Chief of Community Relations for the Department of Safety and Homeland Security. One of my jobs there is handling the FOIA requests that come through. Me and the Delaware State Police FOIA coordinator, we work together with some of the FOIA requests that come in. To answer one of your first questions, it kind of depends with me, at least at my job. Sometimes FOIAs come in a lot during the week. Sometimes it doesn't. It's kind of up and down. I will say right now, it's really a lot with the body cam information coming out. And as I mentioned, I work with DSP with that. So I kind of help with that from time to time if she gets overwhelmed with some of the requests that come through. And what was your second question? I'm sorry.
How long have you done?
And I've been here for about 3 years. It'll be 3 years in December. I never had FOIA experience before. So the first couple of weeks were kind of, just trying to get my feet wet, trying to learn everything. But once I got a grasp of how everything kind of works, everything's been fine since. And just some of the lessons that I learned is that, people ask a lot of, have a lot of different requests. So sometimes it's kind of hard, figuring that out, or somebody may ask for a lot of documents and then, change and say they want one document now they can't get every document. So it's just kind of just a lot of back and forth, but the key word is just kind of patience, with everything, with some of the requests that do come in. So that's some of the best advice that I can give. Just be patient and, you know what you're doing and just kind of handle it the best way that you can. So.
Thank you.
I'm Kelly Pitts. I'm FOIA coordinator for Kent County Levy Court. We don't get as many FOIA requests as state agencies do, but when we do, we get them. It seems that they come in spurts. I've been handling FOIA since I've been there. So I've been with the county for 6 years. I did not do any FOIA requests with any of my previous jobs when I worked for the state. The challenge for me has just been the county rules are sometimes a little different from state rules. So it's just trying to differentiate it, especially, most of our information is public anyway, public records. We handle real property records and mostly all of that can get off of our website anyway. So that's been a challenge a little bit. Sometimes people want things that we have very little that we can't give, but there are times that there's information that we can't. So.
My name is Katie Stobasinski. I'm the FOIA coordinator for DENREC. I've been doing that job since June of 2018. Prior to that, I was at the DOJ. And I got involved with I was in the environmental department on the DOJ side. And I did get involved in actually building the FOIA, consolidating FOIA into the Office of the Secretary. So it was the other side of the FOIA actions. DENREC receives, I think, the most in the state. Most FOIA requests right now, we're over 900 for the year. And I do think that the best, that your comment about the patients is a very good thing, because you have to realize don't take it personally. And, try to it's just a request, and, and to move forward and move through them.
And just to clarify, we're talking about patients, that's patients with a FOIA requester, right?
Right, right,
Okay.
correct.
Hopefully you don't need to have as much patience when you're working with your coworkers
Oh.
and colleagues. You never know.
It's across the board, let's say.
Oh, okay.
For me, anyway.
Hopefully that wasn't aimed at you, Kayla.
No,
I think
Kaylee is my rock, so.
I'm sure we'll touch on later, but especially when you're dealing with large agencies, the coordinator stands at the forefront and holds the flag, but needs to gather information from the entire agency, and that can be difficult when you're dealing with large agencies. So we can touch on that part.
Definitely. So this is a great segue. So how do you get agency or staff support, or how do you get them to buy into their FOIA obligations?
In what sense can you kind of?
So how do you ensure that if you have, a FOIA request that comes up frequently, you need to have someone who's tracking the intake, even if they're not the FOIA coordinator. If the request doesn't come in necessarily to the right person, you need to be able to get that to the right person, whether that's you directly or someone that works with you. So how do you get, or if you need someone to search emails, IT support, things like that, how do you try and get support from everyone so that way you're fulfilling all of your FOIA obligations?
Well, Lisa, on my end, as the Department of Safety and Homeland Security, our administrative assistants, one of them, that's like her job to track the FOIAs when they come in. So everything comes to me, and once I get them, I send the initial notice that I received it, and then I just kind of CC her on it so she can kind of log it and everything. And she's been working there way longer than me, so she has a whole system. So I just let her do her thing. But she has like a file cabinet of all the FOIAs that come in. She prints them out. She has them separated by dates, the months, years. So I kind of just let her do that. On my end, I'm a little more, millennial, I guess. So everything's in my email. So I usually just type a name in. If we're missing something, and it comes up. So that's how I keep track of it. But we do have like an Excel sheet. And like I said, she does have the cabinet file, the folders that's there as well, too. So me and her kind of work hand in hand in that sense. But as I mentioned, like every FOIA request within all the agencies under the Department of Safety and Homeland Security, like comes through me. So like I see everything, and I just work with her to make sure they're in the right place and stuff.
Or Kelly, do you want to?
When I first started, like I said, the FOIA was being handled by all of the divisions and sections separately. They were doing their own thing. When I started and consolidated it into the Office of the Secretary, they were actually extremely happy that they didn't have to be the direct contact. But most of them are still my contact to when I get a request, then we distribute it to whatever section is appropriate. And I do have a very good working relationship with the majority of the staff. Sometimes, a request will come in to some, person that's not at all involved in FOIA, but, they'll send it out to me and they say, I think this is a FOIA request. Are you supposed to handle it? Yes, absolutely. We'll take care of it. So it took a little bit of time to get totally on board, but for the most part, it runs really smoothly, and I do have a lot of buy-in, and especially, like I said, with Kaylee being a great support system for me.
We run pretty smoothly. Everything comes through me. I track them. I funnel the requests out to the departments, and usually I get the responses from them immediately, unless there's something, pretty big that requires a lot of response or gathering information. But they're pretty great.
It sounds like all three of you work at well-oiled machines that all know that you are the point of contact for anything that looks or sounds like a FOIA request. Do any of you have to work with public information officers when there's media requests? Is there there any of that that has to be handled by you?
I have a dual role. That's
Oh, okay.
So
So it still goes through you,
it still goes through me, yes.
but you might have to put a different hat on. So,
Yes.
okay,
Yeah, same for me as well too. Like I said, I'm the chief of community relations, so like anything media, everything in that sense like comes through me. So like I see all of that all the time. So
okay,
if I receive something that comes from, media, then I engage our, public affairs and, the deputy secretary, to say, you know, is this a hot topic? Or can we just proceed as normal? And we, usually it's proceed as normal, but, you know, every once in a while, it's something that's, you know, needs to be taken, you know, a deeper look at.
okay. So, oftentimes as a FOIA coordinator, you serve as both the facilitator between the requester and the agency or whoever might have the actual documents, and the party that sends out the denials or, you know, enforces the requirements of FOIA. How do each of you sort of handle that balance between both facing the requester and supplying that, facing the agency or staff member with trying to get the documents, and also either issuing denials or enforcing the requirements of FOIA?
Whenever FOIA requests come in, I do have other staff members that will look at it and log it into our system and then distribute it. If they have a question that I don't want to say my staff, but the staff members that help me, you know, if they have a question, if it doesn't make sense, then I'll go back out to the requester. Same if we send it to one of the divisions or sections and they need additional information, or they say it's too broad, or, you know, then then they will let me know what they need and I go out to the requester. And then if there is if it needs to be denied, I write up information for my DAG, my ROC, and then, you know, she either denies or she, you know, agrees with the denial, or we discuss it, you know, or do whatever, you know, needs to happen, and then I will send out the denial if it's an actual valid denial.
Do you ever feel like you get caught sort of in between?
yeah, like I said, at least sorry, at least for me, kind of the same concept. I reach out to our DAG. So when the FOIA comes in, for the most part, at least for me, most of the FOIAs are kind of like, most people asking for documents, for at least for us, aren't public documents. So for the most time, I'm usually denying a lot of people. So most of the denials are kind of like the same. So I can always kind of like prejudge like what it may be. So it may be, you know, investigative or something like that. But once I get that, I reach out to Lisa. So once I get the request and what I think the denials are, I'll ask her, are these the ones I need to deny for? She may say, add this, or no, not that. And then once I get her approval, I just usually send out the denial. Then I'll CC my administrative assistant, as I mentioned, so she can log it. So that's kind of the process that I kind of normally do. And even for the documents that are public records that we do give out, same process as well too. I may say, hey, what are your thoughts on this? Or are these documents public? And then she'll respond back and give me an answer to kind of help me out. And then from there, we kind of, you know, do the same concept. So.
Okay, yeah. So, what happens when you have a request that comes in that either you're getting, your staff is telling you this is too broad, or I don't know what they're asking for, or you say, I think this looks like it might be a denial. Do you, when you have to go back to the requester to sort of ask for more information, how do you typically deal with that? Is there any sort of standard language that you put in just in case you don't hear back from them, or is there sort of just more of it just depends on the exact request?
Yeah, at least for me, it depends on the exact request. Like I usually just, you know, send a respond back as like a normal email in a sense. Just like, can you kind of clarify what you're exactly looking for so I can help with your inquiry or something along those lines, just to, you know, kind of keep it broad in general, but I just need more information. And sometimes people respond back and sometimes people don't. But I kind of just keep it like simple like that. I don't have any kind of set language that I kind of use for that. I just kind of just keep it broad like that. So.
Yeah, the only other thing I add in there is a date that I need a response by. And then that way, if I don't receive a response by that time, then I will respond back out to them and say, we sent an email on this time, on this date, we did not receive a response, therefore we're going to close it. Of course, keeping it within, appropriate timeframes, not just, you didn't, I'm going to request a response in a day, you didn't respond, and then, I'll go back out. Sometimes I will go back out to them, just because I know that if they provided the information, we would be able to get them the documents. But, I've gone out a couple of times and just gotten nothing. And so I've just closed it out.
And I think that actually answers one of the questions that that was in the chat about if there's no time frame recognized. Oh, I think this may have actually been referring to fees. We could talk about that too. After an estimate is provided to a requester who does not respond, is the request left open in perpetuity, or after a reasonable time span when the public body can consider it closed? So is that something, would that apply if it's a situation where the request, does go over an hour and you think you need to charge fees for it? And how do you handle that? Do you process it and then wait for the money, or do you ask for the money before you process it? And do you give them, a certain number of days to pay before it's processed or it's considered closed? You can all just maybe speak on how you typically handle that.
We'll contact the requester and let them know what the fee is. Normally, we'll say, we assume once we receive your payment that you'd like for us to proceed. That's the way we will continue. If we don't receive, by the end of the 15 days, we'll get back with the person and let them know, give them another chance. And of course, if they don't pay by then, we'll just let them know that we're gonna close out the request within X number of days.
That's the same thing.
Yep, same across the board for me as well too, same concepts.
Okay.
Can I add to that?
Yeah.
If you're an entity that has a lot of requests and a lot of estimates are going out, you may also put in your letter, we don't hear back from you within a reasonable period of time. We'll consider the matter closed. Then you don't have to do anything more.
Right.
That should be found reasonable. So that's just a suggestion.
What's a reasonable time?
I would say at least 20 days.
Okay.
Like if they could call or contact you in any way, especially if you're emailing, if they don't get back in 20 days about, yeah, we'll pay that.
Yeah, I say something like, if I don't hear back from you
Don't quote me on it.
Yeah.
within
I'm not.
a certain,
So Joe Hamlin said that.
if I don't hear back from you within a certain period of time that you want to pay, modify, or cancel the request, to give them those options, just to let them know that we're just not going to close it out on you, but to give them a little bit of, put the ball back in their court to say, okay, all right, it's going to cost $1,000. I don't need 15 years. I just need this year. And, so that way they would modify it, and then we would do another cost estimate. But we do not provide the documents until we receive the check.
Yeah, I just wanted to highlight what Lee just said, because of how voluminous some of the requests we get in particular are. Lee has taken to putting in that, please let us know if you'd like to fulfill the request and you're submitting payment, or if you'd like to modify the request. I think that really speaks to the intent of the statute in helping maintain transparency and open government and helping the interested citizens in obtaining the information they're looking for. And I think in many ways can also help defeat any complaint that the cost estimate is excessive, because clearly you are making an effort to work with them. So it shows that camaraderie and that, working together spirit.
Yeah, and that is a good point. A requester may not realize with their initial request that what they're asking for is a huge volume of information, when really they want a very small subsect of it. So, but they don't understand that they have to pare it down for you.
Yeah, I was gonna add that, I had a situation where, someone requested something and the cost estimate was like over $2,000. And I offered for her to speak with the person with the information so that it, to give her more information about the program and also to try to narrow down what she was really looking for. And that really did help.
And I know that, I think Kelly, you mentioned a lot of things are available on the website.
Right.
Do you ever say to a requester, if you want copies of, what you're asking for, it would be X amount of dollars, but there's a lot that's available on the website. Do you ever direct them there first, or is that something, okay,
Yes.
a lot of, okay.
Yes.
Yeah, and it is, a lot of our public bodies do have pretty robust websites. That obviously doesn't apply to every public body or every type of FOIA request, but there's a lot of information that's already maintained somewhere. And by directing them there, you can save them money and save yourself some time too, since it's already there. You don't have to go compiling documents.
And also for future requests of a similar nature, they know where to go now and they don't even have to come to us unless they can't find it, then, they might submit a request, but that would be their first step.
Right. So just in general, I know Arshang, you mentioned that you'll see, or you have the same type of denials frequently. If you have just a general estimate, how much of what volume of your FOIA work is a denial?
Like 95%.
Okay.
Yeah, it's very rare. It's very rare that we provide public documents. It depends on what the request is. In my mind, I was trying to think of something that I just did recently, but I can't think of anything. But yeah, usually like 95% of the time, it's usually kind of denied on our end. It's like I said, most people are asking just for kind of like random things in a sense, at least for us. So yeah, at least for me, I denied like 95% of the time. I probably can count on I've been here 3 years. I probably can count on my hand how many times I actually like approve something. So,
And that's based on your statutory
Right.
exemptions because of where you work
Right,
and the
correct.
specific type of
Yeah,
documents you
basically.
handle. Understood. Kelly or Lee, do you have any sense of estimates of denials or?
I've had very few.
Okay, so you're on the opposite end,
We're on the
yeah.
opposite end, and usually it's that we don't compile
Okay.
information. We don't,
You simply don't
use
have
that
those
if we
documents.
don't have it.
Yeah,
30%?
That's about what I was thinking.
Yeah.
As say for us, in-state versus out-of-state has become an issue simply because of the volume that we deal with at Denrick. So I'm not sure how many you'll deal with out-of-state requests very often, but
A lot of them. So.
and that's actually another question from our audience. Actually, this was a pre-sent in question. I apologize. So if a FOIA request is denied due to lack of Delaware citizenship, then the same request is sent from a quote resident of Delaware, end quote. Must the public body honor the request knowing they are sending it to the non-Delaware resident? And I just want to reiterate our disclaimer that anything we say here is not legal advice. You need to confer with your own legal counsel, because I do think that this is a very fact-specific issue and something that different public bodies may just choose to handle differently. But
really quickly before you put it out, in case anyone is not aware of what the body of Attorney General's opinions say on this matter, it has been held repeatedly that the FOIA statute does not obligate responses to non-Delaware citizens. Delaware citizens include, of course, individuals, but also corporations that are Delaware entities. So, but the decisions also emphasize that we continue to encourage transparency and continue shared regardless of the location of the requester, but it is not a FOIA violation to deny a request to someone who is not a Delaware citizen. So with that groundwork.
And there is quite a bit of case law on it, which is why we say, consult your own legal counsel, and that those are opinions you may want to look at in detail. But to our panelists, is that something you deal with, or is that something? Kelly, no? Okay.
A lot of times we'll get it from a a law firm with address in DC that also has an office in Delaware, and we'll deny it for the DC, and then it comes in through Delaware. But it'll come in through a Delaware address, and the documents are sent to the person in Delaware. I don't send them to the original requester.
Okay.
At least with us, I mean, that's kind of interesting. Like, I haven't had that happen yet, but in my mind, maybe I need to like look in to see like what, if that does happen, what do I need to do? Because that hasn't happened yet. As you mentioned, we do get a lot of out of state requests. So, but it's never been, like as you mentioned, where, somebody's out of state and then ask for the same request for somebody in Delaware. Like, I haven't received that yet. So I need to do some, background homework on my end to figure out, when that does happen, what do I need to do? So.
Right. Okay. Oh, I'm sorry.
I did have that same happen to me, and the DAG, Deputy Attorney General's office did help me out. They said McBurney versus Young.
Yeah.
As a man in California was requesting documents from an ex-wife who lived in, I guess, from Virginia, who moved to Rhode Island. Because of McBurney v. Young, the Supreme Court said that because it's out of state, we didn't have to provide those documents. And Delaware adopted the same thing. But you all didn't give me legal advice, but you said, let's look up McBurney versus Young, and I did. So our board decided we would not provide this man information for us on our job because we didn't have to. We weren't violating FOIA, but because we cited McBurney v. Young, and we cited Delaware's law, was very similar. We're not obligated to provide information to out-of-state residents.
Right. Yeah, and again, that's something, consult with your own legal counsel, just so you have their take on it, but it is definitely something that has come up before in the case law. That answered the question. We also did have another question come in too. Is there a limit on the number of times a person can submit a FOIA request? I'm sure you all have your frequent flyers as you are all smiling and laughing over there. So no, is that the answer?
Unfortunately,
No
the
limit.
answer is
No limit. And it's sometimes it's kind of tough because they'll ask the same thing over and over again or something different, but then you'll have like 5 requests from them. And then sometimes myself, like I'll get confused of like which one I sent off and which one I didn't. So like that for me, sometimes that's always kind of tough. So I write everything down. So it's like, I'll go through each one and make sure I sent it off or did like that. Cause this one guy definitely is like that. I know on top of my head who sends requests all the time, but it'll be like 6 or 7 of them from the same person asking the same thing. So it's kind of hard sometimes, but figure it out.
We've had requesters that go directly to the departments, and then they have to send the paperwork up to me to record. So, yeah, we do have those people.
So FOIA logs, we've touched on that. They're very important. I think that was clear. They're required, and just in terms of housekeeping, they're very important to keep everything straight, especially when you're getting multiple requests from the same requester. How much detail is enough? How much do you each typically put in your FOIA logs?
I usually kind of put everything. So like I said, we have an Excel sheet, so it has like the name, the date, and the reason, denial or approval, and then I put the reason why I did XYZ. So that's like all in there. So if anybody has questions, we can always kind of, go back. And as I mentioned before, everything is kind of in my email, so I can see when I sent the message off as well too, just in case it's a backup if it's not in the Excel sheet. But like I said, my administrative assistant, like I said, she has like a whole system. I don't mess anything up, but she has a legit file cabinet of everything. Like she's been working there for like 20 years. So it's like something from, honestly, when I first worked there and was using a FOIA request, I was using those past FOIA requests to help me like send you what language to use or things of that nature. So I would like go through and kind of figure things out. But yeah, I didn't want to get off topic, but yes, that's it.
We have a spreadsheet as well. We have a cell for notes, fees, any comments that we have that we'd like to include with that in case something should happen. And then the date that we sent the information.
We have a database, and so that can compile a report, a FOIA log report, and it can capture anything that we put in, anything that's already captured within the database. Then I can select, if I want the FOIA number, the date received, the date due date, the date, the date responded to. I can select all that and then submit and then make a report.
Okay, so that's probably due to your volume
Yes.
of FOIA requests you have.
Yeah.
It's a specialized software database.
Yes.
Okay.
Yeah. We used to use an Excel spreadsheet, and the difficulty with that was that only one person could be in it at the time. And so, it put a lot on one person. So we moved to this data it's called Next Request.
So, and how do you handle if you get a FOIA request in and you go to your staff to try and get the documents, and they tell you this is an extensive search, it's gonna take me, 21 business days just to get these, let's say they're emails, something like that, where you have to get IT involved. When you do need more time, how do you typically approach telling the requester or communicating that information?
I have a template that I will send out and says, it's going to take, this is a voluminous request. And that's if we don't do a cost estimate first, because it's going to legitimately take 20 days, or whatever, however amount of time, hours within that 20 days. I would send a cost estimate. If we receive that back, then, if we receive payment, then I would say it's going to take X amount of time. We anticipate being able to provide the documents by whatever date. And if we're coming up on that date and I see that we're not there yet, then I'll send out another more information and say, it's going to take a little bit longer. But obviously trying to stay within being reasonable. It's going to be the end of the year kind of thing.
Right.
It's the same.
Yeah, same for me as well too. Same concept. I already have like language written up if I need more time that I send out to the requester and kind of like let them know that need more time or X, Y, Z. So same concept.
That sounds like communication with the requester is key, and
Right,
that's,
correct.
and just telling them as soon as at
Right.
least,
Yes.
and keeping them apprised if something would change too.
Sounds like tracking is a big deal.
Yes.
It is.
And that leads me to my question. Can I get a copy of your tracking sheet on your Excel spreadsheet? Why? I don't want to make one up from scratch. I'm not brand new to this. So if you have one that works and you've already done one for 3 years or 10 years or 6 years.
There is an example that's in the FOIA manual, and there's copies of the manual on the table
Oh,
in the
there
back.
is one example in there?
Yes.
In the back, in the appendix.
So I still have to build it. Now, I'm trying to get somebody to send me a blank.
I was half joking. I mean, we get FOIA requests for the FOIA law.
Yeah, right.
It's real embarrassing when you have to say you have no response to documents. That's actually, okay. So if you don't have a log, get a log going.
You gotta have, see that now.
Yeah.
No, I'm getting,
And I'm sorry if you guys mentioned this already, but the other important thing is we have constant turnover in state government. I'm sure you do in municipal government. You get turnover and people forget, but I've been there where I am for 5 years. So there's been times recently where I'm like, wait a minute. We got this FOIA request. And you're trying to figure out like who requested it and when. If you got good logs, you can find it out like that. If you don't have good logs, then you're potentially responding differently. And if it's the same person, they're like, gotcha.
Right.
2 or 3 years ago, you said objection, now you're producing for vice versa.
That's a good way to emphasize that having a good tracking sheet that you can search is important and can be very helpful, and to save yourself time too, because you're just You don't want to have to reinvent the wheel. And a quick question, because we did touch on fees, but I forgot to ask this, that do you do fees check, cash, online? Or how do you collect the fees? You know, Bitcoin, I'm not sure.
Check or cash.
Okay,
Check or online.
Yeah, check, or I think it's just a check for us, if I'm not mistaken.
okay,
So yeah, I think it's just checks.
Yeah, we have a payment portal,
okay.
and that's the majority of the way we receive payment.
Let's see. Oh, identifying custodian. So if you have several different people that work in your agency, how do you know who to go to that would have the documents?
At least for me, as I mentioned, most of the FOIA requests come from the different agencies. So if it comes from DEMA, it might be a DEMA, something that is for DEMA. I reach out to the director and say, hey, XYZ, I usually CC our dad and like, hey, what are your thoughts on this? They're requesting this, if this is public documents. And then from there, we kind of coordinate whether it is or isn't. And then, like I said, from there, we kind of, once I get that information, then I just kind of relay back to the requester, like, you know, approve, deny. But yeah, that's what I usually do. I usually go to the chain, the main order operation. So whoever the director is of that agency, I usually just reach out to them and just ask them. So,
Okay, so you can usually tell on from the request who
Right.
it would go to.
right. 'Cause
Okay.
at Homeland Security, we just in a unique place where like nothing directly, people aren't directly asking us things. It's usually for the different agencies. So that's what I kind of normally do. So.
Okay, that makes sense.
We get a lot of requests for environmental assessments and I refer them or their webpage.
So you hand them over to Lee.
And it's pretty much the same. I mean, I have a set group of people that handle my FOIA requests. If we get something that comes in that, you know, is kind of an oddball, I'll search our website to see who would handle that. I ask Haley, I ask around who would handle it. But for the most part, I have set designees that we send documents or FOIA requests to. And then if they need to contact somebody else, then they let me know I need to go out to so-and-so and so, but I have the set where the starting point kind of thing.
It sounds like a lot of it's institutional knowledge, just knowing who's in your organization, who handles what. And then when you need to ask a question, asking the right questions.
Correct.
I have a question concerning that same thing. So if, like, you send it to DENREC,
Yes.
does DENREC answer you to go back to them, or do they answer the requester?
That's in their jurisdiction. They
Now,
would answer.
once it and I'll say when it happens to me, if I receive something and it should have gone to, I don't know, it should have gone to DSP. I will say to the requester, this should be handled by DSP. We are closing out your request, and I will give contact information for how to submit a FOIA request to DSP. But then it closes it out for me, and then DSP would be the responsible party to respond. They don't send the documents back to me for me to send them because they're not my documents.
So you forwarded original request to them, or just? We just got one the other day where it's for another agency, which wouldn't be us. They just send it to us saying that they're forwarding it to us. That was it. It's not the actual request. It's the person's contact, but not the actual request.
Because it depends, because if, like, sometimes I'll get stuff that could also go to DelDOT, and I will forward the email that I received to DelDOT, to my contact at DelDOT, and say, you know, we received this and copy the original requester and say, we received this request. We believe it belongs to DelDOT. We are closing out our FOIA. DENREC is closing out their FOIA requests, and DelDOT will be in contact with you. But so they should have sent you I mean, as a courtesy, I guess it's more, is the better way to say that the other agency should have just forwarded you the original, request, and then you would log that as your, as that now being your request.
What the date we received.
Right.
And what we do is just get back to the requester, give them the email or the webpage for DNREC. Give them, give them that information. Please resend your request to that because that doesn't fall up under our jurisdiction. And then that way we're done with it.
Yeah, that makes sense to me at least, then you're not being the middleman between
Right.
the FOIA requester and the appropriate agency or public body, then, you're giving the FOIA requester the correct information or what you believe to be the correct contact for that.
It is important to note that you do need to do your best to direct them to the proper party. That it has been held that simply saying, we don't have anything,
Right.
it does not cut our obligation as state agencies under FOIA.
But does that person, the requester, now have to reach out to us, or is that we just have to answer it now because it was forwarded?
I think that would be a case where it's very fact specific and you probably want to talk to your own legal counsel. Probably someone should reach out to that FOIA requester at some point. That sounds like that's probably how it would be handled.
I
And
would just
also,
answer it. If something got forwarded to me and they copied the requester, I wouldn't wait for them to separate.
Well, in the
I would treat it as a FOIA request as of that date in my.
The email says what the first request, not the actual request.
Okay.
Your request for has been forwarded to, and it was just an email from the other agency.
Okay, so
I would also ask where things were left, the dialogue with this person. So you can kind of just jump in as opposed to, because I mean, common theme here is just keeping these people happy, especially if they're vocal. And if you jump in and say, hey, I'm starting from scratch, re-explaining to me everything we talked about already, that has a tendency to piss off people. Whereas if you're, hey, I'm stepping in for so-and-so at this point, I know we've gotten to this point and want to get you to this point, that's going to play a lot better.
I was gonna ask the other agency, can you send the original,
Yeah, it's,
the actual request, if I have that,
Yeah.
other than the email saying you
I would ask for
tag your,
the status of the dialogue and originals.
Yeah, and if I say, DelDOT has these, DelDOT may have documents that are responsive. Because I don't know if they do or not. I don't know if it even goes to DelDOT, but that's who I think it is. So, I try to say it.
I've been on the receiving end where I send it to the actual agency, but I didn't respond back. I just sent it. So now I'm on the opposite end. So
I believe we have another question from the back.
A request, does it have to be on the former, when you receive an email from somebody saying, I want this information regarding my case, say to a criminal case or something?
It is a valid FOIA request regardless of the form.
Yeah.
The form is merely a formality and a way to assist people in giving you all the required information. But if it contains enough information to know who it's from, how to get it to them, and what they're requesting, it is a valid FOIA request.
Second question. Your retention records, if the state has a document shows you how long to keep those records, is FOIA included? Is it beyond 7 years?
well,
Is that, well, I'm saying somebody wants information about 1351 South North Street, 2023. Obviously, if you don't have those records, you can only provide what you have on hand. I'm saying, when you do the retention part of it, it pretty limits how far back you can actually get information for that party. Say it's a landlord-tenant situation and they've had a lot of problems with this address. And it goes back more than 7 years.
I would say, obviously, consult with your own counsel about the specific facts, but you can only provide what you have. So if your agency is following its retention policy and does not have the records anymore, you can't turn over what you don't have. If they are not, however, following their retention policy and do in fact have those records, there is no exception for something outside of the retention policy.
If I have it, I have it provided.
Right.
Yes, right. Was there any other questions from the in-person audience? If I missed your hand, I apologize. So it sounds like a lot of what you're doing is searching electronic databases. Are there times where you still have to go and search hard copy files?
at least on my end, the only time I search a hard copy file is I haven't been there. So if it's something, you know, maybe 4 years ago, like I've been there for 3 years. So if it's something that I never received before, then I like kind of go back and go through, like I said, she had to count a file cabinet and everything, or maybe go back to the logs to kind of figure everything out. The person before me was doing the same thing I was doing. So I just kept what that person was doing. So they should have a log as well too. So that's usually the only time I kind of do it, when it's outside of something, when I wasn't here, so I don't have that information. I just double check to see if that information is there.
It's rare.
Okay,
Yeah.
very rare to have to go search hard copy files.
Yes.
Same, well, yes, we are moving towards trying to have everything electronic across DNREC. Obviously, that's a monumental task. We're getting there. But as far as paper, are you talking like paper files within the office or archives?
I guess either
Either.
one, yeah, so whether it's just something that's, you know, some type of external storage where it's in an electronic form, but it's not on your typical server. You have to like physically go somewhere else to get it, or if it's some type of unique map of something that's stored in an oversized
Right.
file cabinet.
There still are some of the sections that have paper files. But like I said, they are working towards getting everything scanned. And the kind of the benefit of a FOIA is that when we receive a FOIA request for something that's in the box, then it gets scanned. And so now it's electronically available. So, you know, that does help as well.
That you found a silver lining in that FOIA request, yeah. It got that box scanned and saved.
Yep.
I don't know if any of you deal directly with this. Do any of you have to ask like DTI to search emails? Kelly, I don't think you would it because you're not with the state. No, all right, Lee, you do?
Yes.
Okay, is there a best approach for that or?
The best approach probably is I have to get guidance from whatever section I'm getting the information, like what are the keywords? If the requester doesn't provide what keywords they're looking for, you know, based on the request, we'll talk about, you know, what are the keywords, who are the emails, whose emails do we need? I did find that if a person has left DNREC but went to another agency, they're still within the state, we cannot now get their emails because they've moved, they're no longer our records, they're the other agencies. At least that's what I was told by PTI. So whether anyway, you know, so one of the biggest things with that is when you get the drop back, there can be voluminous records that are totally unrelated to what you're looking for. So non-responsive, I mean, unrelated. And so it's, you know, just having to go through that and trying to weed that out to get to maybe something that's responsive.
Do you go through that manually then? Is that, okay. And that brings us up to another point. If you have to do any redactions, is that something you do yourself? Do you have an admin that assists you in doing redactions?
I do them for the emails. I do them myself.
Okay,
Our department heads.
okay, they do the redaction.
And yeah, I do it myself. So yeah, I usually reach out to our dad or secretary or something just to make sure everything's fine. But then I'm the one that's kind of sitting there
Going through it,
Yep. So
putting those black boxes
Right.
in, okay. Let's see. So third-party confidential information. When we're talking about FOIA requests that would touch on a third party's confidential information, how do you typically handle that? Do you talk to the third party? Do you talk to the requester first? Or is that something you don't have to deal with? No, okay.
Well, there's a admin code for DENREC regarding confidentiality and how requests for confidentiality are to be handled. So, and that also includes if an RFP comes in, they have to request confidentiality of certain documents. So that's handled. That's not me directly, but if we do then receive a request and the documents have not been redacted, then that's kind of touchy, and it's handled like on a one-off basis. But if they've already requested confidentiality, then the document that we would provide would have those redactions already in the document and would have already been approved.
Okay. See if there's any questions that we missed. We did have another question come into the chat. Not all public bodies have websites or employees or IT. Could there be some guidance provided for municipalities or with direct democracies or town meeting form of government in the state? So I don't know that any of you would be able to touch on that. As anyone in our committee presenters, I think they're asking about, we will frequently say that they're talking to the other employees or the staff or the IT. If it's a smaller town or municipality that doesn't have those resources or a website, any thoughts on good practices for FOIA requests?
Like how they're made?
I guess how to answer them, how to sort of process them or maybe track them. It sounds like the tracking, a lot of it is done on like an Excel spreadsheet. So that should be something that probably be able to be doable.
Yeah, I mean, I don't, as smaller they are, I think they have less FOIA.
A lot less.
Some of these state agencies like DENREC and Safety and Homeland Security get 900 a year. I think it's more substance over form.
Okay.
So that they're responding, they're providing records and they're keeping track of it somehow. And they're in compliance.
Okay.
I think, just to follow up a little, my thought would be having a consistent form of file storage. Even if you only have 10 files, make sure that they are being stored consistently so that you can, that you, the FOIA coordinator, can confidently fill out an affidavit saying, I searched our system, I found nothing, and know that you searched what is available and that it was in a format you were able to search. So that you have a confidence in knowing what the universe of documents or records that you have access to are.
Okay. And I think we got another question in the chat about, so I guess the three direct democracies are the municipalities, Arden Town, and Arden Croft. Do they require a hybrid option now? So I think that's probably referring to the virtual meetings.
As far as providing access virtually to a member with a disability who has requested it as an accommodation, yes, that is an obligation. If there is no request, then there is no obligation, but you must be prepared to make that accommodation upon request.
Another question probably as a follow-up to that, if they have to have a virtual option for someone disabled on the council, wouldn't that mean those bodies where the people are the government would need all people, including the disabled, to have a virtual? I think that's meaning, if they have a virtual option for a council member or someone who's on the public body, does it need to be open to the public?
No, that because there's two different statutory provisions that provide for virtual meetings. One is the mandatory, which makes it mandatory to provide virtual access as a reasonable accommodation to someone with a disability. And as long as you are staying in that realm and only providing it as a mandatory, under the mandatory provision, then you are not truly having a virtual meeting. The only time that you move into the virtual space is when you are publishing a notice with virtual access and meeting all of the other requirements under the discretionary. So no, it is not a, well, if it's open for one, it's open for all. It can be requested as a reasonable accommodation by a member with a disability, but only if you move into the discretionary does it become open to all.
And I think, so you think you also answered another question as well. Let's see. Looks like there was another question for the panel. Does anyone on the panel deny out-of-state requests? I think
Yes.
Lee, you already said yes.
Yes.
Arshawn said yes. Kelly, no.
No.
Okay.
You receive them? You receive out of state?
Not too often, yeah, so we just answer.
So they're infrequent, but you were, your Kent County has made the decision to answer this request.
Sure.
Okay. See if I got any other questions here. FOIA names listed on the website, where does it need to be listed? I think that might be referring to FOIA coordinators. Yeah, so FOIA coordinators are supposed to be listed on the website. I don't know that it has to be anywhere in particular on the website, just somewhere. Probably close to where you put in a FOIA request, I would think.
Right.
So
We have a FOIA under like admin law. There's a FOIA selection, and then that has all of the information about how to submit a FOIA, my information, any of that, the form.
Okay.
So.
And there was a question that actually I think was a repeat of the question we had in the physical audience about if an agency forwards a FOIA request because we're the custodian, do we log it the day we received it or the date of the original request? And I think the answer to that was it's the date you receive it. You didn't know it existed until you received it. Another question from the audience, if my department does not handle a particular request, am I required to research and send the requester the information of the department that does? So I don't know if that's a department or that your public body. So if you're within a department that's part of a bigger public body, then you might still be part of that. And Haley, I think you talked about that earlier. You still have an obligation to give them, to tell them what agency or public body is the custodian.
Yeah,
No.
so if the question is regarding requests that are held by a different agency, then yes, you have an obligation under that whole general philosophy of trying to help the individual obtain their records to assist them in finding the right contact information. I interpreted that question though the other way around, more as in a situation like DENREC, where you have a single FOIA coordinator and multiple divisions under it, and a situation where we are having difficulty obtaining the requested records from a particular division. At the end of the day, the duty falls on the FOIA coordinator and the agency as a whole. So Lee, do you want to talk a little bit about what happens when your divisions are being less than cooperative?
The requester files a petition. I follow up, and I document every time I follow up with the requester. I involve the division director if necessary. I involve Kaylee, to remind them that they have this requirement to provide these documents or a response. Even, it's surprising how many times I don't even get, I have no documents. Or I need a follow-up and just nothing, no response. But majority of the divisions are extremely responsive and very timely. But like I said, then we just reached out to, I follow up as many times, and then I pull Kaylee into it, or I pull the division director into it to try to get, a response and remind them that, I have this obligation to get a response, and that just saying, the person's on vacation is not a valid, I can't respond to the requester and say, sorry, the person's on vacation. It'll be, 2 weeks until you get your documents.
Kelly Arsham, do you ever have that issue? No, your well-oiled machines. I got it. No problems there. We do get another question. How long do the FOIA requests need to be kept? Can they be archived at any point? So that may depend on your exact retention policy, as we've talked about.
We do, our DENREC's retention policy is 3 years for the actual FOIA request. I think, like someone said, I think it is 5 years for the FOIA log. But yeah, I remember last year talking about this, and the response was basically to check your retention policy.
And the last question I see on here is, will this recording be made available? Yes, it will be made available. Because we're not gonna have any tech issues this year. So I believe I got through all of the questions from the chat. Are there any questions from the audience? Yes.
I have one real quick. This is more for the presenters. During the, for the meeting agenda, it was like, basically you said there's no catch-all. Does that mean like the phrase is like other business as an agenda item? Something that's sort of like they can discuss anything? Is that to be discouraged from using?
Right, yeah, we would not want to encourage use.
Yeah.
That could mean anything.
Yeah.
The meeting, agenda requirements need to alert a member of the public with an intense interest in the subject that subject will be discussed. Did I quote that right? Thank you, Dory. I was hoping I was saying that magic phrase right. Yeah, so you don't want to have the catch-alls. Obviously, if there's something that's one of the emergency things that comes up that needs to be added, you can add it and explain why it needed to be added at that time.
I see a lot of old business and new business, but then there are topics underneath this.
Yeah.
And I haven't really researched it, but I always thought, because they always debate, oh, is it old business or new business? It might be old because this might be new. And I'm like, it doesn't matter. And I think I'm right. It doesn't matter as long as the subtopic clearly indicates what we're being dealt with, right?
I would think so, because the subtopic would be more the actual topic versus
Right. They're just heading.
right. The old and new doesn't
I
really
think it's
alert.
a thing.
So like, if you took an example, say that you have a town that's going into executive session and they're discussing purchasing a piece of property. Could they just say new business and then have that they were getting legal advice from their attorney about it? Or would they need to say purchase of property at X location?
So if it's an executive session that they're planning on going into, they need to say executive session and list the reason why that topic would fall under an appropriate executive session exemption from the public meeting requirements.
Okay.
As for specifically how they want to capture that would depend on sort of exactly what facts they have and what reason they're giving for that executive session. Any other questions? All right, I did just one last one. This will be our closing question from the chat. Does this include executive session? Is it sufficient to list just the applicable codes? Do I have to log FOIA requests that I cannot fulfill? Let's start with the last one. I think that's a good question for panelists. Do I have to log FOIA requests that I cannot fulfill? Yes.
Yeah, I log everything.
Yes.
Yeah.
Do everything.
Yeah,
Once the request comes in, it goes on that log sheet. Okay.
Yeah, because I remember Sussex County was like, I was talking to him about something. He's like, but do not send it to me. Like, we can talk about it, but he, because he's like, then I have to log it and, have to handle it. And so, yeah, you have to log everything. And I would think it would behoove you to log everything that comes in and how it's handled. So that, you're, if a question comes up, you can say, I received it this date and this is how it was handled.
Right, and just like I think Joe mentioned earlier, if that same request then later comes up two years later, you can just search and say, no, we already did this, it was denied because it fell under this exemption, or it was fulfilled, go see this file for those documents. All right, so if there's no further questions, I think we answered all of the questions. Anyone else have any further comments? Panel, did you have any other pearls of wisdom for FOIA?
Patience is key.
Patience.
Log
Patience.
everything.
Patience in a well-oiled machine, it sounds like. Yes.
My colleagues at the DOJ might hate me for this one, but please don't be afraid to talk to your counsel. It is so much easier for us to do our jobs when you consult us before a problem comes up. let us
Absolutely.
advise you about best practices so that so that we've all laid the groundwork together for how to address requests as they come in, for how to deal with petitions if they come in. It behooves everybody to work together from the outset, and our colleagues who are not in this room can use us as a resource. So they then need the time, though, of course, to contact us as the FOIA committee to answer those questions, to field those questions. So always, please remember, we're not big and scary. I promise. We're here to help you.
I apologize. Was there a question in the back?
It's just a suggestion, like, I work for the Wilmington Fire Department, I'm in the farmer's office, and I do FOIA for the entire fire department. In our section, when you go to the fire marshal's office, we have the correct link for the FOIA request. At the bottom of the FOIA request, they actually have another link, that when you click on it, shows you all the FOIA coordinates of the entire city. That's a suggestion that people could do, and link it right into the actual FOIA request.
Thank you. Yeah, that's a really good suggestion as well. All right, well, thank you. Oh, yes, and please take, if you're here physically with us, there's training materials with the PowerPoint as well as copies of the manual, I believe, back there. And there's also a sign-in sheet if you did want to sign in and didn't get a chance to do so earlier. Thank you so
Thanks,
much.
everyone.
Thank you so much to our panel.
Thank you. Thank you.
Was I-